there would be no limit to what judges might personally think ought to be included as a fundamental right if all they're doing is using the word liberty.
And the whole idea of constitutional analysis is to apply what are the core, the essential parts of old documents to today's conditions.
Indiana's abortion ban gets its day before the state's highest court, and it won't be the last. The ban is on hold while the courts review it.
The underlying question is whether the ban violates the state's constitution's right to privacy. News8's government reporter Garrett Bergquist was in the court chamber for every minute of this morning's arguments. He joins us now live from the State House.
The court must decide whether a trial judge was right to put the law on hold, and that decision could affect how the lawsuit plays out. The man tasked with defending the law in particular got a grilling.
Tell me your argument for us deciding a full merits before the case has been tried out in the trial court.
It's not clear what a trial would cover. The trial court said that there's a right to abortion under the Constitution, and this law violates it.
I did not find they said that.
Confused? Here's a recap. The ACLU says the abortion ban violates the opening words of the state constitution. We declare that all people are created equal, that they are endowed by their creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness.
Liberty has meaning, and its core value is the right to manage the most private aspects of our lives free from unwarranted government interference.
Does it mean the right, for example, to use illicit drugs because it's my body?
If you are talking about things like drug use or wearing a seatbelt, you're talking about a much more de minimis impact on one's ability to have one's own identity.
A trial judge put the law on hold because she believes the lawsuit has a good chance to succeed on that logic. The Supreme Court has to decide whether to let the order stand while the lawsuit itself works its way through the courts. Solicitor General Tom Fisher says there's no point in doing that.
First and foremost, because the legislature enacted this law and they're entitled to have it go into force as quickly as possible. Second of which, I don't know what the trial would be over, as I told the court. What are we going to be sorting out in terms of an evidentiary presentation? We have to know. We have to know the answer before we can have any kind of trial.
Are you trying to pin too much of this on A1S1?
No, I think that this whole question following Dobbs is whether states have some constitutional provision which protects the fundamental liberty interest, which incorporates a woman's right to decide concerning procreative matters.
There's no timeline for when the court might give us a ruling. There never is. Even if the court throws out the case, remember, there is a second lawsuit against the ban under Indiana's Religious Freedom Restoration Act, and there's a second order putting the ban on hold while that lawsuit works itself out. Live at the State House, Garrett Bergquist, Wish TV, wishtv.com, and follow us on Facebook.